For some, the relief of finalising their separation and the desire to just get on with life can lead them to overlook important details that really need to be taken care of. All too often, people don't think to update things like their will, power of attorney, and insurance and superannuation beneficiaries, or ensure that leases, properties, cars, bank and investment accounts, utilities and insurance policies are in the correct names. While they all seem like small details, and let's face it, none of us love paperwork, it is really important that these things are all updated when the separation is finalised. The last thing you want is to find yourself liable for expenses that are no longer yours, or that your ex still technically has ownership of properties or assets that become yours as part of the settlement. If you have children, you might also want to make sure their schools or childcare providers have up-to-date emergency contact information and are aware of any court orders. But most importantly, you want to make sure your agreement and the split of assets is documented and legally binding. If it isn't, there is potential for all sorts of problems to arise down the track. As time goes on, people's circumstances change. If your agreement isn't legally binding, there's always the potential for one of you to change your mind and file for a property settlement down the track. I've seen cases where someone has inherited a large amount of money and their ex has been able to lay claim on it because their original agreement wasn't legally binding. I've seen others where someone has racked up a heap of debt, filed for a property settlement and had that debt included in the asset pool. It happens, and it's unfortunate because it's so easily preventable and avoidable if you just document the agreement with a family lawyer.